Good afternoon, everyone. Welcome to the City of Madeira Beach Code Enforcement hearing. My name is Bart Valdez, and I am the appointed special magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 20 years. I've been appointed to this position in accordance and with the authority set forth in Chapter 162 Florida statutes. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. Every effort will be made to hear all persons having relevant evidence, argument, or comments to offer related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in by the city attorney in just a few moments. In all cases, since the city has the burden of proof, the city will present its case first. The respondent or property owner then will be given the opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and you will be provided with a copy by mail, so please make sure that we have your current address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and to provide you a reasonable time to correct the violation by whatever means is available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline. If you wish to present any information to me today, it is necessary that you swear or affirm that you will tell the truth. Therefore, at this time, I'd ask the city attorney swear in all witnesses.
Swear the testimony you're about to give is going to be the truth, the whole truth, and nothing but the truth? I do. Thank you.
The first case on the agenda today is case number 2021.3332 for property located at 13342 3rd Street East. Is the city prepared to move forward?
Yes, we are.
Go ahead, Mr. Trask.
Okay, thank you. The city would call Holden Pinkard as its witness. Holden, if you could please state your job responsibilities here at the City of Madeira Beach.
I work in the building department. I issue building code violations for the city.
Okay. And how long have you been doing that for the city?
6 years.
Okay. This first case is for 13342 3rd Street East. Is this a case that was created as a result of proactive enforcement, or was it a complaint?
We received a complaint.
Okay. And what was the complaint the city received?
The pad that was being poured, and at the time there was a significant amount of debris in the front yard.
Did you go out to the property to determine whether or not violations existed?
Yes.
Okay. And when you went out to the property, what did you determine the violations to be?
The violations were under Section 86-52 when a permit is required, and Section 110-446. Specifically subsection 2, where building permits are required for all fences. There was a pad that was poured that looks somewhat like a driveway, and then there's also a walkway and a new fence installed.
Okay, and then when you originally noticed the property, there was a maintenance issue of exterior premises originally?
Right.
Okay, and what was that?
That, Section 1469, garbage, trash, and debris, just maintenance of the exterior, that since has been taken care of.
Okay. Who's the owner of the property?
Joshua Rosenthal.
And how do you know that?
The Pinellas County property appraiser.
Okay, I'm going to be talking about the exhibits that are now in the packet. I'm going to start at pages 3 and 4. Is that the printout from the property appraiser?
Yes.
Okay, and it reflects this particular property owned by Joshua Rosenthal?
Yes.
Okay. Did you issue a courtesy notice of violation on June 9th, which is reflected on page 5 of the packet?
Yes.
When you sent this courtesy notice, did you send it by regular and certified mail or just regular mail?
Just regular mail.
Okay, and what was the purpose of sending the courtesy notice?
To let the property owner know that there were violations at the property.
Did you provide in that letter what would be required to bring the property into compliance and then a follow-up date?
Yes.
Okay. And is that reflected on page 7?
Yes.
So the follow-up date reflected on page 7 is June 23rd, 2021. Did the property come into compliance by that date?
No.
Okay. Did you take photographs when you were at the property?
Yes.
Okay. If you could turn to page 8, this photograph here, when was this photograph taken approximately?
This was taken the day the courtesy notice was sent. And you can see the pad there, the walkway on the right-hand side, and the white vinyl fence that was installed.
And that pad that is immediately to the left of the front end of the red car, was that installed too, or had that been there previously?
That was also built.
Okay, so that's in a violation as well?
Yes.
Okay. If you could turn then to page 9, it's a notice of code violation letter dated June 29th. Was that a follow-up from the previous letter?
Yes.
And did that also provide the same violation detail and a follow-up date of July 13th?
Yes.
Okay. Was that sent by certified mail?
Yes.
And I'd like you to turn to page 13 and 14. See if you recognize those photographs and tell me what they are.
13 is a copy of the certified mail that was sent, and 14 is a copy of the certified mail that came back, returned to sender unable to forward. So
how do you know that the property owner received the notice of the code violation if it came back on the certified mail?
When I received that, I believe when I posted the affidavit of service and the statement of violation and notice of hearing on the property, that's when I was reached by the property owner via email.
Okay. So if you could turn then to page 15, which purports to be another photograph, and then continuing on a number of photographs, if you could go through them and explain what the photographs reflect.
Sure.
And when they were taken.
This first group of pictures was taken the original day of the courtesy notice was sent. You can see the pad and the amount of debris. The 2x4s, which I assume are made from framing from making the pad and the vinyl fence. 16, you can see all the debris, the walkway, the new pad and the fence. 17, more of the same. And same with 18, just the fence, walkway, and pad. Okay, on October the 15th of this year, did you issue a special magistrate statement of violation and request for hearing? Yes.
And is that item number pages 19 and 20?
Yes.
It looks like all 3 code sections were still being cited. 8652, permit required, 110-446, applicability of division, and 1469, maintenance of exterior premises. Was it in compliance as of that date? Any of that in compliance as of October 15th?
The garbage and trash was in compliance.
Okay. So did you issue a notice of hearing then for today's hearing to the property owner?
Yes.
And is that reflected on page 23 and 24?
Yes.
And did you also post it on the property?
I did.
When did you post it on the property?
That was posted on October 15th.
Did you also post it here at City Hall?
Yes.
Okay. And is that reflected in your affidavit of service, which is on pages 21 and 22?
Yes.
If you could turn to page 27, which is another photograph, and tell me what that depicts.
27 is a picture of the posting of the affidavit of service, notice of hearing, and statement of violation. They're all in that one posting.
Okay. Have you heard from the property owner since you've posted the property?
Yes. The property owner applied for permits for all of the work, the walkway, the pad, and the fence on October 17th. I believe the permit is still in review. It has not been issued.
On page 28 of the packet, it reflects an email from, it's signed Josh and Jason, but it's from an email address of Jason Dougherty on October 18th. Is that the email that you received?
Yes.
So in the first sentence, he acknowledges that there's a hearing on October 25th. Have you had any conversations with him about today's hearing other than this email?
No.
Okay. And who is Jason in relation to the property?
I believe he is a part owner in the property.
Even though he's not on the title?
Right.
Okay. So did you go out to the property to determine whether or not it was in violation still?
This morning, I went out to the property, and the garbage and trash and debris was in compliance. The other issues have not been taken care of.
How much time do you think it will take to bring the property into compliance with the building permit application process?
Oh, they applied for the permit on the 17th, so it's been roughly a week, and I don't think they've received any comments yet. I think 30 to 60 days is reasonable.
Okay. And should they not bring the property into compliance after 60 days, if the special magistrate gives them that, how much is the city looking for the daily fine?
I think because it's not a life and health safety issue, $100 a day.
Okay. All right. Thank you. I tender into evidence the documents that are marked pages 3 through 28 and ask that they be accepted into evidence on this particular case, and the city would rest.
All right, we'll go ahead and accept into the record as exhibit number 1, pages 3 through 28 of the agenda packet. Let the record reflect that there is no one in the audience on behalf of the respondent or the property owner. There are also no members of the public that are present here today, so there is nobody to, on behalf of the respondent or property owner, to cross-examine Mr. Pinkert, and there is nobody on behalf of the respondent or property owner who is here to present any evidence. I do find that they did have actual notice of today's hearing based upon page number 28 of 32. Mr. Trask, anything else?
No, we'd just like you to find the property in violation of those two cited code sections. Give the property owner at least 60 days to come into compliance. I realize that is December 25th, Christmas Day, so maybe what we'd want to do is we'd want to make it maybe the first of the year. All right. So that they're not working over the Christmas holiday. Okay. All right, and just so I have the correct code sections, it's 86-52 and 110-446? That's correct. All right. Based upon the evidence presented, I do find that there has been a violation and continues to be a violation of Section 86.-52, as well as Section 1110-446, including the admission of the respondent that's in the record in the email. We will go ahead and I will find that the respondent has until January 1st, 2022 to bring the property into compliance. The property owner needs to pull an after-the-fact permit for the fence and the slab, correct? That's the corrective action? That's correct. All right. If the property owner or respondent fails to bring the property into compliance by January 1st, 2022, then there'll be a $100 a day fine thereafter. All right, so I understand we have 3 cases next of old business. All are affidavits of compliance. Mr. Trask, do we need to go through each one or just do them all at once? How do you want to do this? They are all on the same property. Okay. This is the Farrow property, Mr. Farrow, and I believe the home is recently sold. We're asking you accept the affidavits of compliance. I think that you can do that all at one time. But we're just like an order to be entered reflecting each one of those orders, each one of those cases which are separately numbered to be reflected in that order. All right. So for purposes of the record, I'm calling case number 2019.1003, case number 2020.1245, case number 2020.1247, all for the property located at 14011 North Bayshore Drive.
I have reviewed and will accept into the record the affidavits of compliance in regard to all three of those cases, and I will enter an order of compliance on all three of those cases. Is there anything else before me today, Mr. Trask?
No, sir, that's it. Thank you.
All right, that concludes today's hearing. Thank you so much.